difference between then and now, before your lordship. And perhaps as a matter of procedure, where we are now is that my learned friend, I would imagine, wishes to bring an application for postponement to provisional date. So I'm in your lordship's hands, but would it not be more appropriate that he bring an application, and then I answer that by way of our view of the law? Naturally, I'm happy to go right ahead and address your lordship.
I wonder whether you shouldn't go ahead, Mr. Dana, because it seems to me that a lot may turn on whether, as they contend, an application for condonation is required or not.
Indeed, yes. And my lord, in the little time that we've had available over the weekend, I thought that I would support my oral argument today with a note for your lordship, which I beg leave to hand up,
yes,
which sets up in rather more detailed references to the cases.
I see, okay.
So if your lordship would give me leave to do that, I'll hand it up. And copies to the other side as well. So, my lord, let me just presage this by saying that to get to the place we want to be and to inform your lordship fully as to what the position is relating to condonation and suspension and what effect that has on today's proceedings, it may appear rather convoluted, but in the end I think the law is relatively simple, but it takes a bit of time to get there.
Yeah.
So I do apologize if we go around the houses, as it were, but it won't be too long. My lord, what we say is that on page 1 of my note, that the state opposes the application, and we do so because we describe the process of section 17(2)(f), the appeal process, first to put it in its proper context, so that the court knows what it was dealing with and what the new application, which has now moved on from section 17(2)(f), what that application consists of and why it's different. So if you look at the cases of Leashing, my lord, and Klute, mentioned at paragraphs 2 and 3 of our note, it's quite clear that, as Leashing said at paragraph 139, section 17(2)(f) is not intended to afford disappointed litigants a further attempt to procure relief that has already been refused. It is intended to enable the President to deal with a situation where otherwise injustice might result, and does not afford litigants a parallel appeal process in order to pursue additional bites at the proverbial appeal cherry. Klute took it further, and the court will remember that in Leashing 2, this is Leashing 2,
yes,
the court left the question open as to whether a dismissal of an application for reconsideration to the President of the SCA, the court left that question open whether that decision was appealable to the CC, to the Constitutional Court, but assumed that, for the purposes of Leashing, that it was so. In Klute, the court took it further, the Constitutional Court, and there we quote at length from paragraphs 43, 44, and 45, again at 62 and 63, what the position is relating to such appeals, with such applications. In other words, an application for leave to appeal against the dismissal of the President of the SCA's ruling that the section 17(2)(f) appeal should not proceed, that the reconsideration should not be given. And in Klute, first of all, I wish to say, my lord, that at paragraph 43, and overall, the court there, in summary, decided that appeals from the President of the SCA to the CC on this narrow section 17(2)(f) issue were not, there was no appeal in general, unless under very, very circumscribed and special circumstances. At a stage, the court refers to fraud in one instance relating to the section 17(2)(f) consideration by the President, but issues of that nature. So generally speaking, unlike Leashing, Klute would have us apply the law that there is no appeal, unless under very, very special circumstances. And look at what the court said. My Lord, at paragraph 43, again confirming leashing, that 17.2f performs the function of a safety net. It's not a general second appeal or second bite at the cherry, giving the President the power to intervene and so on. And importantly, in doing so, it creates a diversion from the usual appeal process by allowing for the reconsideration by the court of the refusal of leave to appeal to two judges at the instance of the President. The path that the matter then takes along the appeal process is determined by the manner in which the President exercises discretion. And then 44, in the event that the President exercises her discretion to refer the decision for reconsideration or variation to the court, the matter will then be heard by the Supreme Court of Appeal, will be reconsidered, and thereafter may be entertained by the full court of the Supreme Court of Appeal or dismissed once more. In the ordinary course, an appeal against a decision of the Supreme Court of Appeal dealing with the reconsideration may lie to this court, depending on whether it results in a reasoned judgment. Now, this is important at paragraph 45. In instances where the President does not refer the decision for reconsideration, such as in our case, my Lord, the matter would revert to the ordinary default appeal process. This would mean that the decision of the two judges refusing leave to appeal would stand as a final decision of the Supreme Court of Appeal, and appeal may lie to this court against the last reasoned judgment, and that, as the courts would have it, the last reasoned judgment is your Lordship's judgment in this court, certainly on the merits of the matter, if not the merits of the matter read together with the leave to appeal judgment. So, and then if I could skip on to paragraph 62, in 62, and we're dealing now with Klute. On this approach, there is no possible prejudice to the litigant caused by this court not normally hearing appeals from the President's Section 17.2f decision once the President has made a Section 17.2f decision. The litigant has 15 days to approach this court to seek leave to appeal against the High Court decision. So there it is in black and white that Tron J, writing for the Constitutional Court, says that after the President has made her Section 17.2f decision not to entertain a reconsideration or to order a reconsideration, the litigant has 15 days to approach this court to seek leave to appeal against the High Court's decision.
That decision by the President of the SCA was on the 20th of May, was it?
20th of May, yes, my Lord.
Yes.
Yes. And in this, the court is here adjudicating why it is that appeals don't usually lie from the President to the CC, and that is because there's no injustice. It's not necessary that that be so, because the usual appeal process kicks in, and litigants will be well suited to follow that process in all fairness, and we'll get to the conclusion just now.
And that's obviously what the Constitutional Court had in mind.
Yes.
In its order of the 23rd of September.
Yes, my Lord. Later in this note, we make the point, just to jump ahead, that my learned friends make the point that by some miracle of law, an interpretation which is extraordinary, they say that the content of the Court's order, saying that they're not going to, assuming that there is leave against the President's decision, assuming that, and not deciding it. And of course, on Klute, it's a proper decision to make, not to assume that there is a right of appeal from the President to the CC, because Klute has settled the matter in the terms that Klute has decided. Therefore, it's quite understandable why the court should say, assuming that there is leave to appeal, because in actual fact, the Court has decided that generally there isn't. But nevertheless, that being so, the ordinary appeal process kicks in, and all the court is doing we submit, humbly submit, my Lord, that when writing that in the order of the Constitutional Court, all the court was saying is that's the law, and it is the law because Klute has decided the law, and there's nothing unusual or and it well explains why the Constitutional Court declined to order the President to reconsider, and or, more extraordinarily, to order, in accordance with my learned friend's application, to order the SCA to hear the matter, which would be yet another step. And all of that, to put it in other words, is that it's quite understandable that the Court would have said so, because that is the law, And it would not have been in the interest of justice, is what the court was saying, to hear the matter, because the ordinary, as in leashing, two processes are not good. It's not in accordance with the design of the Superior Courts Act, and it doesn't make any sense. So in accordance with leashing and with Klute, the Concord in our matter, we submit, was quite fairly doing what it could to shorten the process, stop this appeal to the Concord, which would result in it going back to the SCA, yet again to flounder in the SCA, and then again make its way up to the Concord in a parallel process, which of course would take a lot more time. And
so what we're left with then is, as stated also in what you've just quoted from Klute,
in Klute, yes,
that the litigant, in this case accused number 1, would have 15 days to approach the Concord to seek leave to appeal against my decision.
yes,
Okay?
yes.
Now the question arises, that application or that route is open. Does it boil down simply then to whether there should be an application for condemnation that accompanies such an application or not?
My Lord, yes.
Is that the issue that we
well,
reduced to?
there's a positive and a negative. The
Yeah.
positive is that in Klute, the court there said that the litigant has 15 days to approach this court, and the court says later on that that 15 days starts running when the president declines the application. So if you read that with the fact that there is no, on Klute's interpretation, which is binding, there is no appeal to the Concord against the president's decision, together with the positive finding that the application to appeal against your lordship's operative judgment, reasoned judgment, should be should start running at the date of the president's decision. That answers the question that it has to be made then, and if it's made later than 15 days, such as in our case it is made later than 15 days, it is out of time. And that has the consequences which we then go on to develop a little further on. So yes, the crisp answer to your lordship's question is condemnation is necessary, and in our present case, it has not even been made. Your lordship, again, to run ahead of our note, will well be aware of the settled principles in Mjeni and in Modderfontein squatters, that the mere making of it wouldn't cure the defect in my learned friend's case here, if they were today to file an application for condemnation, as we say they should already have done. It wouldn't cure it. It would make it slightly better, but flagrantly, we submit, there is not even an application for condemnation. So if you take the two factors together, there is no application for condemnation, so we can't even consider what the result of that would be. But if there were an application for condemnation, well, we don't know what the terms of it would be because we haven't seen it, because it hasn't been made. But if there were an application for condemnation, even the best application for condemnation, in terms most appealable, or I shouldn't use that word, in terms most attractive to the reader, that would not cure the defect in the appeal. And that is on the basis of the authority in Mjeni and Modderfontein squatters, which are quite clear, which say that absent an application for condemnation, there is no appeal before the higher court. And that has very important consequences. It had very important consequences in Modderfontein and Mjeni, and it has important consequences for our case, because it means that all the judgments which have previously been suspended and which your lordship has found against our arguments, but of course we accept that and we keep complaining, but my lord, naturally we operate on that basis. Your lordship has found that your lordship was bound and had a very limited discretion in not granting the application to postpone. And that is part of the matrix of this case. But the fact that there's no appeal pending satisfies the conditions of your lordship's order of the 1st of August, in that appeal process in the Constitutional Court, and I should add, in terms of section 17.2f. And that 17.2f golden string starts right from the 11th of April through the 17th of May up to the 1st of August. It's clear that your Lordship has ordered that what we're talking about is the application in terms of section 17.2f through the courts, not anything else. And that is a well-considered, we submit with great respect, order. We're all happy with it under the circumstances of this case. But now that we are faced with the leashing and Cloete law, together with the Mieni and the Modderfontein squatters law, a different situation emerges, and we don't have appeals which, we don't have judgments of your Lordship which are suspended on your Lordship's orders. We don't have the Supreme Court of Appeal orders which are suspended. We don't have any order by the President of the Supreme Court of Appeal which is suspended. And therefore, thank goodness, at last, this court is free to apply the Superior Courts Act in a fair way, which we say it was designed to operate, and that is to stop interim appeals during trials and to exercise a proper discretion, unfettered by any defects in Section 18 in the Superior Courts Act, and just simply exercise a discretion relating to the interests of justice in this trial. And we say, my Lord, that again, salutary, happily, this court, in a very well-reasoned and properly considered judgment, with great respect, 2 judgments, has found that the application is ill-founded, that the prospects of success in it being overturned are ill-founded. The 2 judges of the Supreme Court of Appeal have found that also, as has the President of the SCA in a limited sphere of Section 17.2f. And so we have your Lordship's 2 judgments, 2 judges of the Supreme Court of Appeal and the President of the Supreme Court of Appeal read together with the dismissal of the application by the Constitutional Court. So I would submit that there's every reason for this court to be able to say, my judgment, well considered, that I have given, that this application is ill-founded and should be dismissed and the trial should continue, that bears the stamp of approval up the line all the way to the Constitutional Court in the various connotations of the law and how it's applied up the line. But nevertheless, the bottom line is, it seems, in fact it is so, that this court's judgment has been approved and that it remains. Therefore, apart even from being bound by the 2 judges of the SCA's order, that there are no reasonable prospects of success, and read with the President's order and with the CC's order, this court is, one doesn't want to make too much of it, to say your Lordship has no choice because that is what the CC and the SCA and the President of the SCA has ordered. That is not so. We don't say that. But as a matter of law, this court, thank goodness, is bound by that law because this court wants that law to apply. It was a defect in the legislation which hindered your Lordship. And the cry from the state is, for goodness sake, let's not properly apply Section 18 now that we can, and let's get on with the trial, because the defects have been cured by this incredibly long process of months, which have deprived us of sort of a year of trial, and we don't need to suffer from that anymore. So I think, my Lord, I was at page 3 of my note.
Yes.
And at paragraph 4, we just make the point, as I think I've made, that the state's grounds for opposing the first accused of suspending the leave can now be summarized, as I think I have, that your Lordship has handed down judgment in October 2021, dismissed the application for leave to appeal in February 2022, 30th of March, the SCA judges dismissed the application. Leashing applies. The President dismissed the first accused application. We apply Cloete, as I've summarized, for your Lordship, which states that, and here is the important point, my Lord, at the end of paragraph 4.6. let's just get it in context. As set down authoritatively in Cluter and detailed above in paragraph 3, the first accused could and should then also have elected to apply to the CC for direct access in the ordinary course of the appeals process, to appeal to the CC against the decisions of this honourable court. Once more, it chose not to. As explained in Cluter, this litigant has 15 days to approach this court to seek leave to appeal against the High Court decision. So it's important in the sense that Cluter was the applicable law when my learned friends for accused number 1, when they chose, flying in the face of Cluter, to ignore Cluter and then go directly against Cluter's advice, against the decision of the President of the Supreme Court of Appeal that there were no special circumstances. They then chose not to apply Cluter, but to go on a strange appeal to the Constitutional Court against the President's order, against Cluter. And why do I make such a fuss of that, my Lord? The fuss is that why would any litigant, apart from very special circumstances which don't apply in this case, one can't even think what they could be in this case, and they're certainly not made out on the papers, as we know from the decisions of the Supreme Court of Appeal and the Constitutional Court. Nevertheless, why would any litigant seek to use that route and not apply on the merits against your Lordship's 2 judgments, the one or the 2 or both, or both together is probably the best way of putting it. Why would they choose to do that and avoid an application on the merits to the Constitutional Court? We say, and we developed this argument in the interest of justice argument, we say that it doesn't appear that there could be any other reason other than that you want to avoid an early Constitutional Court final decision relating to the merits of your Lordship's judgments. Why else would you do it? Because clearly they want to appeal against the merits, but they don't do it. Why is that? They don't want a final appeal judgment from the Constitutional Court because we submit they fear a final decision and that would then allow the trial to continue. And we've argued before that this is in line with what has come to be termed from this case and series of cases, the Stalingrad approach. Now, that's all very well. My learned friends say that they are entitled to apply the law and to use their rights which are given to them in the law. And naturally, that is so. But if it is an abuse, and not even if it's not your Lordship has found we haven't proved in this case actual abuse on the papers which were before this court before, but nevertheless, it is unconscionable to give effect to a litigant who seeks to use a process to avoid what the courts have determined is the correct process. So this doesn't come as a surprise to my learned friends, suddenly now to be faced with having to apply for leave to appeal from your Lordship's judgments on the merits to the CC. They were told in Cluter that that's what they must do, but they didn't. And they're told in Cluter what the consequences are if they don't do it. They have to apply within 15 days, and they don't do it. So to allow that then to cause further postponements to provisional dates, to allow further applications to the Constitutional Court, doesn't accord with the interests of justice which your Lordship should take into account in the broad discretion which the court has, unfettered now by any law up the line, to just get things moving. And that's basically what we want this court to do.
The statement, Mr. Dana, that you say the accused number 1 wanted to appeal, but he wanted to not proceed at this stage with an appeal. Let's take the first part. Accepting that he wanted to appeal, the question of condemnation obviously assumes prominence. If due to inadvertence or whatever, condemnation wasn't applied for, but it's applied for now, the next couple of days or whatever, what must I make of that?
Well, I take great comfort from what the court said in Nyeni. Well, because there, the court will remember that.
Please draw my attention to the relevant paragraphs,
Yes,
because in the nature of things, because this all came late,
Yes.
I haven't had time to look at it, and I don't know whether Mr. Buthelezi has either, but I'll deal with that when I ask him. It might be
it's
a very persuasive.
25 and 26, and we quote it at paragraph 14.14 of my note.
14.14.
On page 8, to the end of 4.14, sorry,
Yes.
4.14.
Mieni versus organic
organization, under
the OTA case.
Yes, indeed.
Yes.
And it's paragraphs 25 and 26. And the court will recall what the facts were in Mjeni. There, it all turned on the suspension of the applicable order which removed her from her directorships, I think. And if that order was suspended, then she could go back to being her director. It appeared in Mjeni that the application was late, the application to appeal was late, and it was 1 day late. So the SCA then, no, it was the Gauteng.
This is Gauteng, Pretoria High Court.
Yeah, Pretoria High Court in Gauteng. So that's even more relevant to this case, my lord, because your lordship is sitting in the High Court, as was the court in Mjeni. So they were faced then with 1 day late application for condemnation, which would make an enormous difference to the result of the case. Now, the court in Mjeni could have taken the view, as your lordship is now debating with me, but the application for condemnation up the line to the I think the Supreme Court of Appeal in that case is a day late. We don't know what the SCA is going to do, or the courts up the line are going to do with it, and it's not our duty, it's not our province to get involved in a decision about what the courts up the line are going to do. That's their problem, and therefore we're not going to exercise our discretion to allow this suspension to continue, and we'll order that the matter continue. Now, 1 day late, and so in other words, the grossness of the application for leave to appeal and condemnation being late wasn't really an issue. The fact is that absent condemnation being granted, the order remains suspended. So in our case, we say that your lordship should proceed in exercising this court's discretion on the basis that nothing is suspended.
Whose judgment was this? In Mjeni?
It was Tom Number, thank you. Thank you, my lord. I'm indebted to my learned friend. So that is the one interesting thing of Mjeni. So in as much as it's attractive to say I'm not empowered and I don't wish to get involved with adjudications as to what the courts up the line will do, Mjeni says you can. And that is as it affects the current case. It's not an attempt to exercise jurisdiction over the courts higher than we are. It's just an attempt to rule this court's own processes in relation to the law as this court interprets the law, which this court, of course, is quite entitled and well able to do. So there's nothing wrong with that. And it happened in Mjeni and the other cases relating to the suspension of orders in the face of uncondoned appeals. The second important thing about Mjeni is that the court there was quite happy to pronounce on the prospects of success of the application for condemnation, as it affected the court adjudicating this matter. And Judge Mlombo, my learned friend, reminds me. So in other words, it's also attractive for a court sitting below to say, I don't know what the court up the line is going to do and how it's going to adjudicate the prospects of success. Therefore, I'm not going there, and let's just continue as if there's going to be a successful application, or there might be. And that's what we've done to an extent. We've done that in this court when we try to urge upon your lordship that this court should take a view on the prospects of success, which your lordship has already ruled on.
Yes.
But anyway, that argument we've made, and the proceedings have proceeded in accordance with that. But now, this is a different issue. We have authority, and we have the law, which says that this court may adjudicate what the prospects of success are, And what are the prospects of success, assuming then that I'm right, that condemnation is necessary? That condemnation would have to seek condemnation for a period of months, number one. Number two, the condemnation would have to say why deliberately, contrary to Klute, my learned friends chose not to address the merits and to try and take that up to the Constitutional Court when that was the obvious thing to do. Furthermore, they would have to address the merits of the case itself. In other words, address your Lordship's reasoning relating to the prospects of success. And this court has found emphatically that there are limited prospects of success. There are no prospects of success. There are no reasonable prospects of success, such as to trigger a successful application for leave to appeal. And that's not all, my lord, because that decision relating to the prospects of success has been confirmed by the two judges of the Supreme Court of Appeal in emphatic terms, either that there's no jurisdiction to appeal at this early stage of the trial before it's even started and during the trial, or because in any case the application in terms of section 1061H is not a good application and doesn't have any merits. But so your Lordship's judgment, together with the Supreme Court of Appeal's two judges, which once again I say rather carefully, are binding on this court, and happily so. This court is free to make an adjudication on the prospects of success, and that of course affects this court's overall adjudication as to the prospects of success in relation to the application for postponement. So that's a very long way around of I think, I would submit, explaining the law, which might appear to be very complicated, but in fact is very simple. So, and my learned friends, in trying to develop that argument for condemnation, which of course we haven't seen, because they choose not to give us an application for condemnation, even after we warned them weeks ago that we were going to argue that your Lordship's order had now kicked in, that the trial is going to start on the 7th of November. But they don't. And they now seek, I would imagine, unless they bullheadedly proceed and try to convince the Constitutional Court that they don't need to apply for leave to appeal, it's going to be a difficult application. So that being so, the court is in a similar position to Mnyeni, where it's very attractive to say, oh, well, let's just wait. What's another month or 2 or 3 or 4 or 5? Because the Con Court in due course will decide this issue. They might decide it quite soon because the application is in and the state has to answer. I think yes, yeah, their application is in and we have to answer and they have to reply, of course. And it's possible that the Con Court could, on the papers, dismiss the application, in which case this court would then be even more free to go on. Or it could ask for argument and heads of argument and a trial date, etc. And that traditionally and in all of our experience takes a while. So then we're looking at way into next year, May, at the very earliest. And we've learned in this very case that there are delays for whatever reason, good or bad, in the Constitutional Court and in the SCA in dealing with leave to appeal, even when the answer comes out quite simply a dismissal. But be that as it may, that is what happens, and we have to deal with it. And that brings me to my learned friend's application, that they seek this court to stop proclaiming trial dates, stop reserving trial dates, and to postpone this case way into May next year, precisely to allow them now to luxuriate in the further litigation that they seek to wrongly now to pursue when it should have been pursued ages ago. If they'd launched, instead of the Section 17(2)(f) appeal to the President, to the President, and gone directly from the final judgment of the two judges of the Supreme Court of Appeal directly to the CC, way back at the beginning of last year. The beginning of this year. We would be a long way further in this trial, and we would have greater certainty as to the law relating to interference in trial proceedings too early, resulting in Stalingrad and dismay amongst members of the public and anyone who has reasoned views of the operation of the law. And we, and with great respect, my Lord, this court has done all it can to try and prevent that. And fortunately, we're now in a position where we can now prevent it from going any further. And if it were to be that condemnation is granted, which we say the reasonable prospects of that are slim, and that should weigh heavily with your Lordship, and if, against our argument, the Constitutional Court allows the application for leave to appeal, even to be heard, perhaps even to interfere with the findings of this court as confirmed by the Supreme Court of Appeal and the President of the Supreme Court of Appeal, in that unlikely event, the effect on this trial also, we say, will be a matter for the trial court to determine at the end of the trial. So the deleterious effect of going on now, read with the possibility, which we say is scant, that the Constitutional Court would interfere, even that scant possibility doesn't necessarily lead to the conclusion that we should let that process go on.
Well, it depends what it decides, doesn't it? If it follows the argument advanced by the first accused on Section 1064, whatever the merits thereof may be,
Yes.
then the hope is, certainly his hope is, that it will lead to an acquittal.
Yes, but then again, we've urged on the court, I think previously in our papers, that is also a scant possibility, because it doesn't make any sense, and for all the reasons that we've previously argued, which I'm not going to go into again.
Yeah, 1064 is a strange provision, I must say. I'd like to hear what a higher court decides on it one day.
My Lord, yes, and again, it would be lovely for the Constitutional Court, in line with Tutor and Leishing, to give us guidance relating to the conduct of trials in the current circumstances. And I say that against myself, but that's not how we work. And if that were so, if we could luxuriate in wanting to wait for the Concourt to pronounce on all things in all trials, which bother us as we go along, we'd never finish any trial. And the Concourt doesn't want us to operate in that way. The courts, including the Concourt, have said time and again, that's not the way that we operate. We must get on with things, finish things, and appeal in the usual course of things in accordance with the design of the Superior Courts Act, which, of course, as your Lordship knows, was changed precisely to try to deal with this issue imperfectly, as this court has also found, of course. So going on then, just to finish the note, my Lord, we say we make the point at 4:15 that there's nothing that is suspended, and for that reason, one of my main tasks is to convince this court that, as my learned friends would have it, we're just carrying on the orders which started on the 11th of April. So what are we making all this fuss about? And the answer to that is, well, things are different because there's no current application as there was previously. And therefore, this court is at large to do the right thing, as we say, and find that the interests of justice are that we should continue. And then at 17, we just took trouble there to quote your Lordship's order to your Lordship, just to make the point. And I see in my learned friend's letter, they appear to say that the 1st of August application, the 1st of August order, because remember, the orders were the 1st of August, going back to the 17th of May and going back to the 11th of April. But that we all accept that the 1st of August order, the latest order, which I don't have a transcript of them, it's a bother, but the latest order is in terms of Section 17(2)(f). So that being so, the situation now is different because 17(2)(f) has come to an end. So the court now is applying a different test, and we're not. It's not without reason that we're digging in our heels again now. It's because the situation is different. And, my Lord, then that concludes the legal position relating to suspension. As I say, it's deceptively complicated, but actually when you analyze it, it's relatively simple. The further section in the B chapter of our note,
Yeah.
just to support my oral argument, is just that, as we've argued previously, that the interests of justice require that this court order that the proceedings proceed. We've argued before that Your Lordship has a wide discretion. This court, as I've also argued before, would agree that it's now unhindered by considerations of being bound by suspensions. And we quote the trite law that it's in the interest of society that guilty persons should not evade conviction. An accused person is deemed innocent. We take that on board, of course, in line with Von Feyfer and other cases. And the effect of the refusal to adjourn on the constitutional rights of an accused must be considered. And once again, I know, my Lord, Your Lordship, it has bothered Your Lordship previously that why to cut off now the appeal, or to order the trial to proceed, in a sense cuts off an appeal process which is the right of an accused person, and that you're denying his right to appeal. Well, when you have conduct which we say is egregious, calculated to avoid final decisions, then that has to be thrown into the pot, and that somewhat attenuates the accused's cry that you're preventing my rights of appeal and you're interfering with my constitutional right. And in any case, now that, my Lord, that Your Lordship's judgments are not suspended, and that the Supreme Court of Appeal judgments are not suspended, we know that our courts, up to the highest courts, recognize that appeal processes must be exercised at the correct time. It's in line with the Superior Courts Act, it's in line with the Criminal Procedure Act, it's in line with the design of the Superior Courts Act to exclude the Criminal Procedure Act. But so in other words, to say my right of appeal has been taken away from me because I can't do it now is not an argument, because our law regulates when that right of appeal must be exercised, and it says it's at the end of the case after a conviction, if there is a conviction. So that argument has now full force, that it's not an argument to say that you're depriving me of a rights of appeal. You've got your rights of appeal, but the law says you must just wait. We refer to Aitchison's case, which is the wonderful judgment of Muhammad A.J., as he then was in Aitchison in Namibia, which he says that the discretion is wide to give postponement, and necessary means reasonably necessary in the circumstances of a particular case. An expedient refers to what is advantageous, proper, or suitable to the case, judicious. And that's really sensible and trite law. I'm just going through my note just to make sure I haven't left anything out, my Lord. I think I've covered everything. I've said everything in paragraph 17. We reiterate that that the current application is out of time. It's based on a deliberate decision. And just look at this, my Lord. We are mystified. At paragraph 18, we quote paragraph 172, which is not before you. In fact, it is before Your Lordship, because no, it's not before Your Lordship, because no, my learned friends put their notice of the application, not the full application. But it's common cause that in paragraph 172 of the first accused affidavit supporting his current out-of-time application to the CC, he states as follows: this is now an application for leave to appeal against the merits of Your Lordship's judgment to the CC. He says, and I quote, "The Constitutional Court must therefore overrule the order of the SCA and to require it hear the merits," I should have put sick, "require it hear the merits of the appeal with a view to providing a reasoned judgment so that justice can be seen to be done in matters involving Mr. Zuma." So what Mr. Zuma asks the Constitutional Court to do, once again, the Constitutional Court having ruled that it won't do so, he says, the CC must overrule the order of the SCA and to require it, in other words, the SCA, hear the merits of the appeal with a view to providing a reasoned judgment so that justice can be seen to be done in matters involving Mr. Zuma. And this is now Mr. Zuma's complaint, perennial complaint, that it's not good enough for courts to give orders dismissing applications simply because they have no reasonable prospects or that it's not in the interest of justice. He insists that in each case he wants a reasoned judgment, full reasons, discussing the head, blah, 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 and not in the terms that the SCA, as they do more often than not, and as the Constitutional Court does, time without number, as your Lordship and this Court have done since time immemorial, dismiss unmeritorious applications on the papers because they are not good applications. So even now that we on the merits before the CC, he wants the CC to go back to the SCA, and both in Leashing and in Kluter, the CC said that it's not the CC's province to get involved in disputes with the SCA, and that if the CC wants to overrule the SCA, the CC must do so, not tell the SCA to do what the SCA has already said it doesn't want to do. So it's just something we picked up, which of course is contrary to the main application or the terms of the prayer. But why does Mr. Zuma say things like that? And it's not surprising, because that has been his attitude in papers from the beginning of this case, with great respect. And my Lord, yeah, so what we say is, and it's against me to argue this, my Lord, because we said in the beginning that your Lordship has a broad, wide discretion. You're not bound by the other cases, your Lordship decided the contrary. Now that it suits us to say that this court must give effect to the Con Court and the Supreme Court of Appeal judgments because they're unsuspended, it would suit us to say, well now you don't have a wide discretion, your discretion is now more limited. We don't say that. We pursue our argument, which we must. I submit, my Lord, that this court has always had a wide discretion, and now that this court is not bound by other courts and suspensions and defects in the Superior Courts Act, this court can now exercise that wide discretion. And we say that the court should exercise it in our favor and let the trial just proceed, as this court has already provisionally determined, so it's nothing new. My learned friends, in the face of that order, simply write letters. Don't bring applications either to this court or to the Constitutional Court for condemnation, and want to refer it back to the SCA, etc. So we're not happy. And my Lord, in reading through the cases, we picked up Judge Kampepe's remarks, Justice Kampepe's remarks in Zuma, here, paragraph 21. Oddly enough, Zuma versus Secretary of the Judicial Commission in the CC, that like all things in life, like the best of times, litigation must at some point come to an end. You can't carry on and on and on forever. And Kluter repeated that, Judge Tron in Kluter repeated that, where she said that the fact that you cut out the 17.2F application for leave to appeal to the Con Court, the fact that you cut that out and say that in general you can't do that, it's not unfair, because at the end of the day, that application, without that little intermediate application to the Con Court relating to 17.2F, there's nothing wrong with it, but because there is an ordinary appeals process, and that it entails orders from the trial court, the two SCA judges, the president of the SCA and the CC will be involved, and it's perfectly fair and non-prejudicial to say that the matter has come to an end. And that's what we're trying to do in this case, is to end the pre-trial litigation and just get on with the evidence. My Lord, I must just also address one further question, which is not in our note, and that is that my learned friends in the letter to your Lordship say that they're going to bring another application to remove me. Our answer to that is that this court has ruled on that, and whether or not any judgments up the line are suspended or not relating to title, if they're suspended, well then the previous position pertains that I have title because I have always had title. If they're not suspended, well, then your lordship has in any case ruled that I have title. So we take exception. We note that it's been done. We take exception, but I will be here going on unless your lordship, of course, orders
It
otherwise.
raises, I saw it, and it raises some concern with me, because obviously they're now proceeding on a different, slightly different basis, and that is that there's this private prosecution
Yes.
that's pending. Now, in my main judgment, the issue of a possible contravention of Section 41(6), I think it is, of the NPA Act was mooted. And I dealt with it as one of the 14 grounds. Well, when I say I dealt with it, my judgment proceeded on the basis that the wide meaning contended for of the words title to prosecute by Mr. Zuma was not what Section 106(1)H intended. But then I went on and I said, these grounds that were advanced in support of the wider as grounds for your removal were at best or possibly grounds that should be considered later on during the trial as to whether he's receiving a constitutionally fair trial. Probably at the end of the trial, but in exceptional circumstances it might even happen during the trial, in the discretion of the trial judge. But then I said that even if I was wrong in approaching the matter on the basis that a narrow meaning was the correct one, then I nevertheless rejected the application for your removal or for the lack of title because I didn't think the 14 grounds had been established or that they were good in law. And in dealing with those, I expressed views, and some of them more strongly than others, but I expressed views also on the interpretation of Section 41(6), as I recall it, and whether it would afford any grounds for stating that you have a lack of title. Now, if an application of this nature is renewed, or they contend that, I think it was on the basis that you shouldn't appear today or be allowed to make submissions and the like, can I really appropriately decide that? Have I not, by expressing previous views, strong views? And it's not only confined to the Section 41(6) situation, it might also be in respect of some of the other grounds. But it came to me in particular when I read the last letter from Mr. Tusini this morning, raising this issue that you now have raised properly with me, whether I can decide that, because I've expressed views, which at the time I think were correct to express, but whether, with the benefit of hindsight, whether they haven't compromised me. For example, if I should say that it's fine, you continue acting, or an application for a postponement, or any similar type of argument be refused, then I might be accused of having previously indicated a disposition to decide these issues in a certain way. It's quite a tricky thing.
Indeed.
And it's all, it unfortunately all comes on our path quite rapidly because of developments in the last 48 plus hours. An argument that you've advanced this morning, which has a certain appeal. I've still got to hear what the other side says. I don't know whether they're ready and have prepared on all the cases that you've referred to the same extent. But it's just something that's it's brought to the fore all the more today, although I have had some concerns over the last couple of months, but I haven't raised them because I thought that until we reached a point in the whole appeal process where, assuming my judgment was correct, the ultimate court of appeal, the Constitutional Court, would say that the special plea was bad in law. Accordingly, that 106.4 doesn't apply, and we're now into the, quote, merits of the trial, the evidence. And then really those points would arise. So I didn't want to raise it beforehand. I was trying just to manage the process. But it seems now that it might have been brought forward, particularly in the light of this argument that is foreshadowed in Mr. Tusini's latest letter.
My Lord, if
I don't know whether you've thought about it or whether you need time to, but there it is. I think I've endeavored to explain as best I could some of my concerns, and I think it's something that the party should be aware of should they wish to make representations or submissions.
Indeed, my Lord. My Lord, I don't think it falls upon me. I don't think your Lordship is, with respect, asking me to give a final answer.
No.
But what I can make a couple of points.
We need to at some stage, however, address it.
Yes.
And I suppose a lot will depend on what happens today,
Yes.
or in the light of this argument.
Yeah.
But yes, sorry, you said you might
Yeah,
want
yes,
to.
sorry,
You haven't
two
considered
things.
it fully, but you might want to make a few points.
Yes,
Do you rather want to reflect on it and make them, having marshaled your thoughts, or are you happy to continue?
No. Well, I think your Lordship might.
Right.
Well, this might be an appropriate answer for me to make now. Let me put it that way. Firstly, to speculate about what an application might be is putting the cart before the horse, because we don't have such an application. We have the warning of an application. So we would respond in due course, depending on what the nature of the application is.
May I just interrupt you on that? I understand the letter, and I might be wrong. It is raised as an issue. And then a couple of paragraphs further down, I got the impression that it was, well, we leave it to the court to deal with. And I would be extremely reluctant to deal with it on that basis. I think if it's an issue of merit, which it might be, then the parties must make submissions, or then indicate that they do not wish to make submissions. I wouldn't like to just having a debate with myself, wanting to decide that issue. I think it's deserving of a lot more attention.
Absolutely.
And it's an important trial. Well, all trials are important, but this is an important trial, and the approach that is to be followed must be one that's beyond reproach.
Absolutely.
Yes.
Well, we take that all on board, and I'm indebted to the court for raising the issue. I think it's important that we all consider this seriously. But I do think, my Lord, that it's not only that your Lordship would prefer not to do it on the basis of correspondence in letters. You know, I would say that the court
Yes.
couldn't do that. It would not be right.
You know, it's one of the other loose points today. There are lots of loose points that are floating around.
Yeah.
And I'll hear just now from Mr. Buthelezi, because that might determine a lot of what happens today or within the next couple of days.
And could I then just make the second point, which I wish to make, which I think I can make now, and that is that it's very attractive to say, well, as the court might be aware, we have applied to quash the private prosecution, and that will take place before hopefully a full bench, or certainly a bench of this court, on the 8th and 9th of December. So that is after the notional sitting from the 7th to the 2nd.
I have avoided too much involvement in that for obvious reasons.
Anyway, so
and I don't want to comment on it
No.
because it's an issue before another court, but it's also an issue that I've already expressed certain views on as to whether a prosecution will be sustained, but I don't want to repeat them, because in no way do I want to be seen as anticipating what that court might decide.
Indeed.
But yes, that might address part of it. I don't know, depending on what the outcome's going to be. But there's still also the other grounds, the other remaining 13 grounds on which I also express certain views.
The argument as to whether your Lordship or not was correct to express those views is confined to the merits of your lordship's judgments,
Yes.
which we've dealt with and other courts have dealt with. So I don't think that is proper, that this court should have addressed those issues because it was relevant, we submit, to the issues at stake at the time. But just lastly, my comment in this respect is that this court is dealing now with an application for postponement. And in as much as it might be relevant what is happening in other courts relating to me as the prosecutor, might well be relevant to the application for postponement. And it's attractive, it would superficially be attractive to say, well, my goodness, on the 8th and 9th of December there will be a hearing, there'll be a judgment sometime after that. We're not sitting in the first term of next year, if I remember correctly.
Yes.
We're only sitting,
I think Mr. Roux had a commitment already.
We're only sitting in some dates in the second and third terms, depending on my learned friend's availability. So there's enough time to let these matters settle down in the other courts, which might solve the problem. The only problem with that is that there's then the appeals process. And once again, just relevant to the application for postponement, if those sort of issues are to affect postponements, then we're back on the treadmill of what we say is litigation designed to...
Well, once again, prima facie, and let me perhaps not live to regret this statement, the appeals process and delays, suspensions that follow in an appeals process are peculiar to the particular proceedings. What happens in another court that might have an impact, I don't think would be grounds for a suspension.
That's a good
But
point.
I say that tentatively because there might still be an argument about that, but there it is.
So, my Lord, then just to conclude, I don't think that from my part, it would be proper for me to take it any further. Those are my provisional views. In fact, strong views relating to this postponement.
Yes.
So we urge your lordship to take into account what we've said, and if necessary, I'll reply to my learned friend.
Yes. Mr. Buthelezi, are you ready to start now? Do you want
Indeed,
to?
my lord.
Okay.
Thank you. My lord,
There's quite a lot that's been raised this morning. I don't know to what extent are you
we'll deal with it in its core bits, my lord.
Okay.
The first one, we've got to start where we left off, my lord.
Yeah.
Now-
As I raised it, I actually thought that's probably the point we should have started at.
Yes. my
Yes.
lord. Now let's start where we left off, and how we end up here in
Right.
this way now. And I'm going to address this point to you first, my lord. I'd like to believe at the last postponement, I was the one appearing and doing that postponement. Two things. We agreed firstly that the accused didn't need to be here because the purpose of today would be to address administrative issues in as far as whether we resume on the 7th of November or what is the outcome of the processes from the higher courts.
Yeah, certainly in my mind, I was hoping that the procedures on appeal would have been finalized.
Yes.
If the appeal was, leave to appeal was granted, then today would have just been a postponement pending that hearing.
Thank you, Mike.
If leave to appeal was refused, and the process had been exhausted, then I would have said to the parties today, second accused, you must get your representative across from France for the date in November. State you must start getting your witnesses lined up for the 7th of November. That's the sort of
Now,
two sides of the coin that I was looking at.
it was not my intention to start at this point, my lord, but I have to bring you to this point first because what the state has now done is put your lordship in a very precarious position in what they've done this morning. In particular, I'll tell you why. The time now is just over an hour since we started. And we've had arguments about Mr. Zuma, quotation of his affidavits in the Concord, in his absence in a criminal matter. It was not the intention of today to run criminal proceedings in the absence of the accused. Mr. Downer has now run an entire argument, okay, impugning the accused. If I can tell you what of the words he's used against the accused, I don't know how many times he used Stalingrad. He's gone and said, we're stalling the matter. And he even gone as far as accused him of egregious conduct in his absence in a criminal matter. Now,
What are you saying
the
then?
point I'm saying to you, Lord, my Lord, is that it should have never happened to begin with, because it was incumbent on you, my Lord, to say, you've now gone beyond what the intended purpose of today is. Because if the arguments you want to make before me go directly and speak to an accused's right to appeal, then we adjourn the matter, bring the accused here, then you proceed. That's the first point.
Yes.
The
Well,
second point.
Yes, sorry?
The second point. On what basis are these submissions made? There is no postponement application before your Lordship. On what basis must we now answer to these authorities that they all of a sudden have been recited before the court? Because what happened prior to today? Your Lordship arrives this morning and says, oh, I see there was an exchange of correspondence. How does that happen? Historically, in this matter, when this matter started in May 2021, it has been the practice between all sides to write to the judge and state their positions ahead of the matter being heard. Either your Lordship responds or doesn't respond. Unfortunately, in this instance, our letter came out on a Friday afternoon. They responded and we responded again on a Sunday. Nothing in those letters was to say, your Lordship is to take a certain position with regards to certain issues. Everybody ventilated their side. And where does the letter of the 14th come from? It comes from Mr. Downer's letter that was issued on the 29th of September, where he wrote to your Lordship and said, oh, the Court has decided they've dismissed them. We'll get to that point. Therefore, the matter must proceed. We hadn't filed our application by then, and we waited to file our application within the time that we needed to file the application. Then we filed the application and we communicated our stance with regards to the issue. Now, your Lordship only picks up the issues this morning. Rightly so, because as far as today was concerned, this was a status meeting where we tell you what we've done, they tell us what their views on that are, your Lordship decides. Instead, we've come to this morning and been subjected to an entire legal argument on a non-existent application. That, my Lord, and the fact that it's been done in the absence of the accused now speaks to the Section 35 rights that of the accused that have now been jeopardized in this matter. Now, before...
Just in fairness on that,
Yes, madam.
Mr. Downer did indicate at the start that he thought that there would be, he anticipates an application for a postponement from you. And he raised with me whether it should start, the argument should start with him or with you. And it seemed to me at the time, just from some of the correspondence, and the question of whether the now appeal, the application for leave to appeal that was filed on Friday, whether it should be accompanied by an application for condemnation or not, was an issue that was germane to that question. And it's on that basis that I thought, well, we might as well hear that argument. You'll be able to reply to it. And if what he contemplated, because that's how I understood it from the correspondence, that there would be an application for a postponement, we would have to wait and see. Your point, as I understood it from the correspondence, was there's an appeal pending. Therefore, Section 18(1) of the Superior Courts Act. But then the point he was raising is that there wasn't an appeal, proper appeal, or an application for leave to appeal pending because it's out of time. Now, I've just picked up from what you've said a few lines back also, that is it part of your argument, and I'm asking, that the application for leave to appeal was filed timeously,
Yes.
being on Friday,
Yes.
being 15 days from the date that the Constitutional Court issued its order. So you are saying, just to try and cut to the chase on that the 15-day period referred to in Rule 19(1) of the Constitutional Court rules when it refers to calculated from the date of it being refused, doesn't run from the date of refusal by the President of the SCA, but it runs from the date of
The order
the order of the Constitutional Court.
of the 29th of September, of the 23rd of September. Correctly, madam. That's our position.
All right. So
Then-
in essence, then you're really asking for a ruling, if you like, on in a declaratory sort of almost a nature, although it's not on papers, that no application for condemnation is required. You're not saying that you are wanting to bring one and you are applying for a postponement.
Yes. That's exactly our
Okay,
position,
okay.
madam.
All right.
Because
Well, then you know, it's part and parcel, I suppose, in regard to today's proceedings, as to whether the trial of the 7th of November continues on the 7th of November or not.
yes.
So I don't think it's germane to what we're dealing with today. I can understand your submissions, but I don't think it was improper to deal with it.
Well-
And if you're feeling, because your last submission now was you feel that the Section 35 rights have been imperiled or threatened, I don't think those were either of the words you used. Compromised, was it? Or whatever word you used. But anyhow, you feel they were implicated.
Procedure.
Are you saying then that this matter shouldn't proceed any further today, this argument?
Not yet, madam. That wasn't the nature of my submission. I was
see.
flagging it because it was not my core submission. My core submission is one, based on your first question to Mr. Downer this morning. The issue turns on condonation. The issue then becomes, were we supposed to file a condonation application or not? We have not filed a condonation application because we did not need to file a condonation application. And if you follow Mr. Downer's flawed logic, it tells you this. His misquoting of Kluter, it tells you this is how it should have played out. On the date that the president of the SCA refused to reconsider the 17 or dismiss the 17.2F application.
That was the 20th of May.
20th of May. Two things should have happened. We should have filed an application to the Court appealing the 17.2F application simultaneously with an application appealing your judgment. That's an absurd proposition, my lord, with respect. Because how would the Constitutional Court, and all of these flawed submissions that Mr. Downer makes with respect stem from his not reading the order. Because if you read the order of the 23rd of September, and for the sake of completeness, I will, madam. It says the following. In the second paragraph, it says this. For purposes of this application, the court has assumed, without so deciding, that a decision of the president to dismiss a Section 17.2F application is in principle appealable, and that application engages the jurisdiction of this court. Two things. One, the Constitutional Court does not say to us, you may not appeal the president's decision. They don't say that. Two, they say, in as far as you raise your appeal, your application, we concede that you are invoking our jurisdiction. We move to the next point. It says this. The court has nevertheless concluded that it would not be in the interests of justice to grant leave to appeal the president's dismissal of applicant's Section 17.2F application. Interests of justice. Mr. Downer raised the point. What does the 17.2F imply? Implies that once we've appealed to firstly, we applied for leave to appeal to the SCA says no. We then petition the president says no. Then we appeal the president at the Constitutional Court. Two things there. Your judgment of 21 October or 26 October 20 is still standing in line. It hasn't moved. It hasn't been considered on the merits at any point, because there's a secondary application that's emerged regarding what the president of the SCA has done. And the Constitutional Court then answers and says, well, we haven't considered the merits of your 17.2F. In the interest of justice, this is what they say. Having regard to the fact, and I place emphasis on the word fact, that the applicant would be entitled, another emphasis on entitled, to seek leave from this court to appeal the High Court's judgment to this court. Now, the Constitutional Court order that Mr. Downer seemingly has not read says, having regard to the fact. This they say in September, and he now tells us we should have appealed in May. So I'm thinking, with respect, my lord, the entire calculation of how condemnation would arise is erroneous, with respect, because we could not file one application to the Constitutional Court appealing the President's 17.2F decision, and at the same time appealing your judgment in the 106.1H. What's the Constitutional Court supposed to do with those two applications? Because your application is what the 17.2F application is about. How can they consider your 106 application separate to the 17.2F? I'm not too sure if your Lordship is with me on that point.
Yes, no, I was just correcting you. You said my application, my judgment.
Sorry, your judgments. I beg your pardon, my lord.
Yes.
Your judgment of October last year. Now, the absurdity of this proposition that Mr. Downer says, sorry, with respect, is to say we should have parallel run those two applications. What are we asking the Constitutional Court to decide? What happens when the Constitutional Court says, no, the President was wrong to refuse the 17.2F, refer the matter back to the SCA for reconsideration, and another group, quorum in the SCA, says Kun J was incorrect on the 106.1H. Conflicting judgments, one is still going back to the it was never the intention of the court. We could only, on a proper application of the law, appeal your judgment with the leave of the Constitutional Court after exhausting Section 106.1H. Now, what further complicates the problem for Mr. Downer is his failure to read Section 18.1. Okay?
118.
18.1 of the Superior Courts Act. Suspension of
Okay.
suspension, and I think the wording is important. It says 18.1, subject to subsection 2 and 3, and unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision which is the subject of an application for leave to appeal, or an appeal. What do we have at the Constitutional Court on Friday is an application for leave to appeal. There's no way then we could have dispensed with 18.1 at this point, because we still have an application. Whether that application is inclusive or excludes a condemnation application, 18.1 says this hearing here today remains the subject of an appeal. And until the Constitutional Court has pronounced itself in as far as saying, 1, we dismiss this application, you did not condone; 2, we don't grant you condemnation, you never asked for it,
Or
then
it's not accompanied by an application for
that's
condemnation.
the factual position.
So if you should have filed an application for condemnation
Yes.
and you deliberately haven't, you're saying that's an additional string to the state's argument.
No, that's not what I'm saying, my lord. I'm saying to you,
Now, if it was required and there isn't one,
we're saying
then it's an argument.
Yes.
No, I understand you saying
Yes.
that there isn't one required.
Yes, my lord.
But if the Constitutional Court was to find that there is one required,
Yes.
and there isn't one, well, then the application for leave to appeal will be dismissed.
Yes, indeed.
But now, what do you say about, and I haven't read it because I wasn't referred to it before, the Mjeni judgment and Mlambo JP's
Well,
statements in those?
interestingly, I had to cite the paragraphs for him because I was in that matter myself
Okay,
with Mr. Mpofu.
all right. Tell me what the
It's
outcome is.
distinguishable on two grounds, my lord. In fact, on one primary ground. What happened in Mjeni is that there was an actual condemnation application pending
Was this before the
SCA.
trial judge or before a full court?
It was a full court, my lord. It was 3 judges.
So this was was it that a court of 3 judges was
Yes.
convened, or was it an appeal to a full court?
Was convened.
Was
because
convened.
it pertained to an 18.3 application to enforce an order pending the appeal.
Yeah.
I've got personal knowledge of the matter. Now, two things which don't find application here.
Yeah.
In that matter, there was an actual condonation application for the late filing of the application, which was filed 1 day out of time. We say that does not arise in this matter because there is no out of time filing of an application. So many principles do not apply. And what those principles say in that matter is a simple point. It says, when you have filed a condonation application, what sits before the court then is actually not an application for leave to appeal. Prima facie, it is an application for condonation. And until you make it past the hurdle of condonation, only then would you have certainty to know as to whether you have an appeal before that court or you don't. Can't be applied here.
On the basis that your argument that no application for condonation is required.
Yes, indeed, madam.
If an application for condonation is required, then it would apply.
Then it kicks in there.
Right.
That's the only stuff. And,
Yes.
and that's the basis we say the reliance on Mieni is also misplaced.
That means we're back again to this point of, is an application for condonation required?
No, it's not. That's
No, no,
that's
no,
our submission.
No,
If that's Mr.
I
Downer's
understand your
argument-
submission,
Yes.
but I'm asking, we back to that point. That's the
Yes.
decisive issue.
Yes. What he should be doing, if that is their case, they must file their papers in the Constitutional Court and raise that point there. And tell us there in the Constitutional Court on what basis the Constitutional Court must refuse to hear us. But this court cannot now make a determination, and the jurisdiction of this court is limited in that regard, to make a determination once a case number is issued by the Concourt, accepting our application, to now conclude it from this level to say, oh, the fact that you have a case number from the Concourt is meaningless, you're late. That's for the Concourt to say. Because once we file that application, the Chief Justice will then issue us with the directions that tell us, one, we're not going to hear you. Two, we will hear you, do 1, 2, 3, 4. So effectively, what we should have done today is present Your Lordship with this here scenario which I'm presenting to you now. The options that we have. The first one is, in light of what we know, because this is not an appeal, it's still an application for leave to appeal. So the scenarios present themselves in this way. Scenario 1, leave to appeal is refused. What does that mean? End of the road for us, we come back to this court, we set a trial date. 2, leave to appeal is granted. The application is heard. The application is dismissed. Brings us back to the same route, we come back to this court, we set a trial date. Option 3, leave is granted. Application is heard and granted. Brings us back here to come tell Your Lordship that we've prevailed in the 1061H. Mr. Downer is stripped of his title to prosecute. Then we must make a determination on whether we proceed in terms of 1064 or we proceed the normal trial in Mr. Downer's absence.
Now, the 1064 surely would then be decided by the Concourt.
They could not. So if you go back to Porritt, that was the point in Porritt. And Porritt...
It was in the court our quo it arose.
Yes.
It fell away in the SCA
in the
judgment
SCA.
because the special plea, as I term it, was refused.
But the point I'm saying is that it doesn't always follow that if you are granted 1061H, that it automatically equals to 1064. So that's the point I'm making about Porritt.
No, I understand that, but
Yes.
I understood the appeal from my judgment, to include that point.
Yes, it does.
That once what Mr. Zuma is saying, that if the 1061H plea was to succeed, he'd be entitled to an acquittal. It's implicit.
It's implicit, and I'm saying it's not automatic.
Okay?
Yeah, it's not automatic. I'm just saying it doesn't necessarily follow that by your success in 1061H automatically means you are acquitted in terms of 1064. That's not our reading of the legislation. It says 1064 comes into play, you may be acquitted. The court may still exercise its discretion. In other words, that's a diversion, my lord. But anyway, so I think I've dealt with the core of the issue. And the core of the issue is, one, there's no condonation required. In as far as Cloete is concerned, if he wants to invoke Cloete...
Yes, you said Cloete was not correctly quoted.
No, it's not correctly quoted, and I'll tell you what happened. Because Cloete says, you've got 15 days, and we complied with the 15 days to the Constitutional Court after the 17.2F dismissal. So we've never been out of time in any of the applications. We've never condoned a single application in any of the appeal processes.
But is that correct? Just look at, have you got it there, Rule 19.2 of the Constitutional Court Rules. It's the proviso that we're dealing with.
Yes, ma'am. Yes, ma'am.
Provided that where the President has refused leave to appeal, the period prescribed in this rule shall run from the date of the order refusing leave. Leave being refused by the President, or leave being refused by the Constitutional Court.
We don't hold the same view, madam, because the President, we didn't seek
Well, no,
leave.
no, that's why I'm asking you.
No, we didn't seek leave from the President. We've never sought leave from the President. What we sought from the President was a variation or a reconsideration.
Sorry, the order was from the President. You sought an order. What leave would be referred to there then? Provided that where the President has refused leave.
If I read properly,
where would the President of the SCA refuse leave, other than in a Section 17.2F situation? Didn't you seek leave from the President?
No. If you read it with what our prayer to the President was not for leave to appeal, was for reconsideration in as far as referring the matter back to the court in terms of 17.2F. I think the issue is the President refuses leave. If you read Rule 19.1, my lord, this pertains to Rule 17.2A, and we were doing 17.2F. And I think that's where the distinction is, because the President may, in terms of 17.2F, refuse leave to appeal. So this reliance that on Cloete pertains to 17.2A. Our procedure was in terms of 17.2F. And 17.2F, you may not get leave to appeal from 17.2F. 17.2F is a specific application asking the President of the Constitutional of the Supreme Court of Appeal to reconsider the decision of the judges in the Supreme Court of Appeal, ordering them to either hear the matter or vary the order that they granted. That's 17.2F. But we did not seek leave to appeal from the President of the SCA. That's not correct.
I don't know whether you've had an opportunity to look at the commentary by Erasmus on Rule 19 of the Constitutional Court Rules.
Not at
And
the
as I
present
said-
moment, but
Yeah,
I'm here for a postponement, and I've been ambushed into this application.
Well, let's leave those words out of it. But
Yes.
it is submitted. I'll just quote it to you.
Yes,
If you're able to deal with it, please feel free.
Yes.
If you feel you have to consider it, then because that was one of the issues that I was concerned about when Mr. Dana addressed me, because these are not straightforward issues, and they're being presented now where I've got heads from the state, but nothing from your side, and there might be authorities that you want to refer to. But anyhow, it says, it is submitted. This is the author now in the commentary. It is submitted that for purposes of the proviso to Subrule 2, that's Rule 19 Subrule 2, the period prescribed within which to lodge an application for leave to appeal in the event of a reconsideration as contemplated in the proviso to Section 17.2F commences to run from the date of the order refusing leave to appeal on such reconsideration.
See?
Is that not saying what you're saying?
No, because if we have to go back to the order of the Constitutional Court and read what the wording says. The wording of this order says, we're not going to consider the merits of whether one, you may appeal or not appeal, 17.2f. I mean, so we don't consider the merits of your application. What we've said to you is that it is pointless for us, in the interest of justice, to deal with your appeals piecemeal. Okay? Which means we will not deal with the 17.2f if we find in your favor and then refer the matter back to the SCA for those judges to reconsider. You lose it there, and then you come and bring it back up here and you appeal it to us. Do it this way. Deal with the matter there. Let's put the issue of the 17.2f, bring your main application here, and let's deal with these matters in the interest of justice. That's what they say. They say it would not be in the interest of justice for these applications to be dealt with in that way. So what was the intention of the Constitutional Court there? Let's read into it. If they say, we're not dismissing you because you've got a bad case. We're not dismissing you because we don't believe in the merits of your application. We're saying we've stayed considering the merits of your application because doing it in this way would not be in the interest of justice. What we but think you ought to have done in this case, or what we think you should do, is bring your High Court application, because where we are point in time, you still are entitled to do that. The Constitutional Court would have told us, this is the end of the road, we dismiss your Section 17.2f application, and by the way, you may no longer bring your High Court's application in the absence of a condemnation application, given where you are and how much time has passed by. They do not say that.
But in saying the applicant would be entitled to seek leave from this court to appeal the High Court's judgment, isn't it implicit in that it must be an application for leave to appeal the High Court's judgment, which means that if it's out of time, if it happens to be out of time, it must be accompanied by a condemnation application.
Then it should have been out of time in August when we were here, because the 17.2f.
Oh, that might be so.
That's my point. We postponed. Now we go back to your lordship's judgment itself, which says, let's exhaust the entire string, or whatever rope that there is, in the higher courts, and then come back. If the argument is we should have dealt with in August, we were out of time, then the argument should have been raised then to say you no longer have a live appeal in the Concord because the years have expired. That was not the argument in April. We postponed this matter in August. We postponed this matter precisely to 17 October because there was still an appeal. And 17.2f
was the issue.
So the point I'm saying is it can't happen both ways. And this is the absurdity that I keep referring to, that says, the implication that says we should have run two simultaneous applications to the Constitutional Court. One, appeal your judgment of October last year simultaneously with appealing the 17.2f decision of the President. Those two positions cannot coexist, man, with respect. We could not do that process simultaneously. And for the fact that the 17.2f was still in play, it kept us, in terms of the main appeal, still alive. Where condonation would have kicked in is this week. Condonation would have only kicked in this week if, after the order of 23 September, we missed the deadline. Then any subsequent process that we would have initiated with the Constitutional Court would have been subject to condonation. While we had that window post the order, nothing triggered condonation. I've got no further submissions. I don't know whether you need me to address you in any other point. Sorry, my lord, can I just check? My lord, if I may deal with this one point that we dealt with initially. True. I need to place emphasis that before your lordship today, my lord, there is no postponement application by ourselves. In as far as the correspondence sought to intimate in that direction, it was only as far as indicating the status quo to your lordship. If it was our intention to launch an application, then we would have launched the application for postponement as we have always done. And I would have been the first to speak and not been the one giving an answer to an application that I didn't make. That's just bizarre. And
So you're saying that it was correct that Mr. Dana would proceed first?
no, I'm saying to you, my lord, there is no postponement application. So I don't even know what are we deciding.
No. Just on the point that he
Yes.
said there's a postponement application, whether he should start or not.
There
You
isn't.
say there is no postponement application.
Yes.
He started. So all I'm saying is you don't have an objection to that then. That's correct.
Well, he is dominus litis in the matter. He is the prosecutor. He may make his submissions to the court. But the point I'm clarifying for your lordship is that it is incorrect for there to be an understanding that says we've brought an application postponement.
No.
We've come to update the court on where we are in the appeals process. That's as far as we've come to do today. And as far as our letters proposed dates and issues about holding dates is to say, look, pragmatically looking at the matter, this is what our view on the issue is. And then the last point. Your lordship flagged it in as far as the private prosecution is concerned. We don't raise it now, but what we want to do is place it on record so that we are not in the future accused of acquiescing in his participation in this matter, when as a matter of ethics and principle of the legal profession, he should be erring on the side that protects the integrity of these proceedings. Whether he thinks there's no merit in our argument, whether he thinks that our private prosecution is frivolous and whatever they've accused it of, that's fine. But the fact of the matter is there's a matter being heard in this court, as the fact of the matter is that he is an accused in that matter. And while that prevails, for the integrity of these proceedings and for the integrity of the organization that he represents, he should step aside, to borrow a term from places I've heard on TV. That's all.
Yes. No, I'm sorry. I have some questions for you.
Yes, ma'am.
The other points I raised on my deciding those issues, are you able to address me on that? Do you want to do so in due course?
Is that the point about the commentary in Erasmus?
No, that I've expressed certain views in my judgment on the grounds including the private prosecution.
No,
And the
we're
like.
not going to venture into that because, and as far as our letter states it, we didn't raise anything that pertains to yourself and what you've stated in previous judgments in the letter.
Yeah, but if it's something on which I've commented before that might peripherally be involved as an issue of relevant consideration in the present debate, where does that leave the court?
Well, it leaves it incumbent on your judicial conscience, my lord, with respect.
Yes.
The same way what we say now, we leave it incumbent on his prosecutorial conscience.
No, I understand that it's
Yes.
ultimately a decision.
We're not
for
going to
my-
express ourselves on that point anyway. If we were to, then we'd come to your lordship with a proper explained argument and view on the
Yeah,
issue. I'm not going to
that's-
make submissions from the bar.
That's where you would apply for it. But you're correct that it's left ultimately to my judicial consciousness or conscience. My inquiry, more specific, is that in deciding that issue, I think it's only appropriate that I invite the parties to make any submissions they wish to make.
If
And-
you invite us to, my lord, we will.
And that's the opportunity that I'm talking about now. Is it something that you want to consider?
We will consider it, my lord, but the
Yes.
point is I cannot make those submissions from the bar right now.
All right.
We'd have to sit and discuss them constructively because
Where do you foresee the matter going from here? If I'm with you and I don't direct that the matter proceed on the 7th of November, then what is the order that you say should follow?
As how we've conducted it, Madam, I said there's 3 scenarios. First one is the Constitutional Court refuses leave to appeal. We communicate that to you immediately. The parties gather, a trial date is set. That's the first one. Second, we are granted leave to appeal, and based on what the directions are, whether the state files papers, whether the second accused files papers, we'll then have a sense of the potential duration of the matter based on what the directions from the Constitutional Court are. Because we've had matters involving our clients where the Constitutional Court, we filed normal papers and the court told us come here in 3 days. We don't know how those decisions are made. So we wouldn't want to mislead this court. All we'll say is that a reasonable amount of time, like you gave us last time, to say, look, you want to go to the SCA and potentially the Concord thereafter. Okay, I'm thinking 4 or 5 months is sufficient time for you to come back. So our estimation, my lord, is that we should have a holding date for at least the first day of the first term, of the second term of 2023, for us to come back and update you. Because
Sorry, just give me that date again. And second term.
second term, in other words, at the start of the second term, I don't know what the dates for the terms are next year off the top of my head. We're thinking because it gives us one, we don't have much left in November. November is just about 1 month, and then the term kicks in to kick off only in Feb. So we could either come back at the end of the first term and help you schedule, or at the beginning of the second term, either or. I think that way would give us sufficient room to come back with a position that's more concrete than the speculative position that we hold right now.
The difficulty is that I've previously asked, for dates that council are not committed. The difficulty is if you come back at a much later date, assuming, of course, now that the Constitutional Court dismisses the special plea, or doesn't uphold rejects the appeal. If you start finalizing dates then for a trial, with the number of counsel involved, it's going to be much, much later. Shouldn't we tie those up as well?
In all fairness, my lord, I would then ask that we stand down, then I consult with my leaders.
It's one thing to have the holding date. I understand your submissions on that.
Yes.
It's the second part of it.
No, I'd have to take, to refer that back up to my leaders, and maybe we could take a tea adjournment, and after the tea adjournment, we could come back with a much more clearer position on how we handle that.
All right. If I want to invite the parties for representation submissions on my position, in fairness on the ad interim partem rule, when do you suggest that be heard?
May I also
Because it's
refer back-
obviously it's something that needs to be resolved beforehand, because depending on the outcome of it, it should be resolved before any evidence is laid.
Indeed, madam. I would then ask that be the second point that I revert back to you with,
Right. Okay.
because we are a big team.
Yes. Anything further?
No, ma'am.
Thank you.
Thank you, ma'am.
Just before we take the short adjournment, Mr. Roo, you want to say anything?
No, my lord.
Mr. Dana, you've got your right of reply, but I think let's take the short adjournment because we've been going for quite some time, just as a comfort break to those who might require it as well. We'll take a short adjournment. Court will rise. Perhaps before I hear you, Mr. Buthelezi, have you managed to take instructions and
2 points.
yes,
Thank you, Madam. One, it's about the dates. Mr. Mpofu spoke, he had a brief discussion with Mr. Roo, but I don't know what they concluded, but the inclination is the start of the second term, because we would then have better line of sight in terms of where we are in the matter. Prior to that, given how things turn at the Concord, could be fast, could be slow.
start of the second term for
Yes.
the trial to resume.
No.
If
To
the,
for
what, just
for
as
the
a holding date,
Yes, madam.
it's 4 months hence.
From here.
Yeah.
We're thinking, my lord, because possibly, even if we are heard in a shorter space of time, to give provision for reserved judgments, if judgments are reserved, because even a judgment dismissing us would be reserved in any event. So we're thinking prudently in light of
And if
the
it
fact that
happens-
we're going into recess for 8 weeks in December. That for us seems a more prudent
So
date.
we don't quite get 8 weeks, we get 6, but nevertheless.
Okay, counsel is 8.
Yeah, and then when the trial to resume. Like you know the order that I've been granting up to now, in the event of, you've got nothing on that.
Nothing on that.
Okay. And the issue of my continued involvement,
Well, we didn't formulate a view, but the simple thing, my lord, is to say we just need to place it on record how our thinking was brought to this, was also in the 41-6 private prosecution.
yes,
That part of our thinking comes from your judgment of 21 October at paragraph 240.
yeah.
And if I may read it to you, I don't know whether your lordship is aware.
Well, there also, I think there are also further paragraphs at 246.
Yes, but
Yeah.
the primary one that for us is the following. It says, well, a lot of things, but ultimately what it comes to, it says, your lordship says, but these are simply ruminations without the benefit of having heard considered argument.
Yes,
If it is believed that the provisions of section 41(6) outlaws such conduct, then a formal charge in that regard can be pursued, where the proper application of section 41(6) can be fully ventilated and its proper interpretation determined. So
but that has now happened.
that's what now happened.
Yeah.
Also,
And what's the impact of that?
that's where we're not going to comment, man.
But where does it leave me?
Well-
Can I decide on my position as you said I should, without? Do you want an opportunity to make representations?
No, man.
You don't want to.
No.
So
You
I
decline.
must just go and decide that on my own. And
Indeed, so.
you're happy to do so?
Yes, ma'am.
And then I'll make a date by which I will then make my position known.
Yes, ma'am.
Okay. So accused one doesn't want to make any representations on that. Yes. Is that it, Mr. Buthelezi?
Let me just verify with
Yes.
the two. At this point, none, my lord. If anything comes up before the hearing, then we'll let you know.
Yes.
Thank you, my lord.
Sorry, before you, Mr. Dana, Mr. Roo, on this point of, well, I've got to consider my position. Does the second accused wish to make anything?
No, my lord, we're not going to make submissions.
Thank you. I can just go and reflect on it myself.
It would seem so, my lord. But we're not making submissions.
Thank you. Yes, Mr. Dana, back to you. Perhaps on this last point, firstly, are you happy that I just reflect on it myself, or do you want an opportunity for the state to make representations?
My Lord, we have full confidence in your Lordship's decisions, but of course we don't want to be unhelpful and say that we're not going to help. If your Lordship would find it useful.
Well, it's more at the
to have
level of
submissions.
I think I'm required
Yeah.
to invite the party should they wish to make submissions,
Yeah.
and that's really the purpose of why I've done this. But you must tell me whether you wish to make submissions, whether written perhaps or otherwise, because it might also influence this date, because I think it's something that I must get out of the way first.
Yes, my Lord, but we're a bit at sea because there are your Lordship's thoughts now, but there's no application from the other side. We haven't made an application. We will not make an application. We will oppose an application, and our submissions will be that your Lordship has not been compromised in any way, other than the usual pronouncements which judges make in cases as they go on, in all sorts of trials within trials, matters.
You're happy that I decide the issue for myself?
Yes, but my Lord, that must not be taken to mean that we don't want to assist your Lordship.
Yes.
We are very, very happy to do research or whatever assistance your Lordship would like on the law, for instance. But your Lordship would take it that we do not support an application that your Lordship should...
well, there's no application. It's really whether...
Yeah,
I've got to reflect on it myself.
So I take it then also that the court is thinking along the lines that there doesn't have to be an application. It could be mero motu.
No, it's not at the instance of the parties.
Yes.
It's there's quite a bit of water that's flown under the bridge in the meantime.
Yeah.
That I must just make sure that the process is beyond any reproach.
Indeed.
Yes.
Thank
Yes,
you,
Mr.
Lord.
Dana.
Well, if I could refer to my learned friend's argument,
Yes.
just some things. First of all, the passage in Mieni relating to whether there is an appeal or not, if the rules of court are not complied with, is at paragraph 26, and it says that in conclusion, the learned judge there says the application for leave to appeal in the present matter has lapsed. So there is an application. So I'm now interjecting. So there was an application. There is an application before the court. It's in paper. It's there, but it had lapsed in terms of the rules of court. In order for the application for leave to appeal to be revived, condemnation will have to be granted by the SCA. Until such time, there is no application as contemplated by Section 18.5 of the Superior Courts Act. And the ineluctable consequence is that the Section 18.4 appeal is not competent on the facts of that case. And so the point is that my learned friend, as I took him to argue, was saying, yes, there is an appeal in the Concord. It's there. We don't take issue with that. We've confirmed that with our attorney because we've confirmed that it is there. Whether it complies with the rule of court, we say it does not. And if it doesn't, then there isn't an appeal for the purposes of Section 18 or 19. And that's on the authority of Mieni. As opposed, the passages in Kluter, which deal with my learned friend's argument that it's absurd to expect us to make a dual application. I think that's his argument.
Yes.
The first answer to that is don't make the 17.2F application, because as the court says in Kluter, it's pointless, because it creates a dual appeal process which is not in the interest of justice, and your application will always be refused unless in very exceptional circumstances. And the passages there are at 60, where the court there says, in my view, this approach is simply
6-0.
In my view, this approach is simply not consistent with the interests of justice. This is especially so where there's a readily available mechanism to prevent any injustice, let alone a grave injustice. This is to direct that a litigant dissatisfied with the President's decision must instead seek leave to appeal to this court against the High Court decision on the merits. Indeed, Rule 19.2 of this court's rules expressly recognizes this. It states that while leave to appeal must be sought from the court within 15 days of the delivery of the judgment being appealed against, this is subject to the proviso that where the President has refused leave to appeal, the period prescribed in this rule shall run from the date of the order refusing leave. And then the court goes on at 61 to say, my lord, that rule has been interpreted to refer to the refusal of leave to appeal by the Supreme Court of Appeal, as opposed to the refusal of the Section 17(2)(f) application by the President. And its intent is clear. Once a litigant has exhausted the options in the Supreme Court, she may then apply for leave to appeal in this court within 15 days. So that deals with what it means the President is referring to the President of the Supreme Court in his role as the head of the Supreme Court of Appeal, and who then refers it to the two judges. And that all in globally is the decision of the President.
Yes.
And then the court goes on to say, on this approach, there is no possible prejudice to the litigant caused by this court not normally hearing appeals from the President's Section 17(2)(f) decision. Once the President has made her Section 17(2)(f) decision, this litigant has 15 days to approach this court to seek leave to appeal against the High Court decision. So that's what I say, that it is extended to the decision of the President, and that's where it stops.
Yes.
In terms of Klute. Yeah, and my learned friend made much of the interpretation of the Constitutional Court order. He says I haven't read it. On the contrary, we have read it very carefully, and it is just simply what Klute requires parties to do. And on the dual application, my lord, just to return to that, it happens frequently that litigants apply both to the Constitutional Court for direct access from a decision of the High Court, for whatever reason, but at the same time realize that the Constitutional Court might dismiss the application, refuse the application, on two principal grounds. Number one, the Con Court doesn't like hearing matters directly without hearing from the courts below in reasoned judgments, or at least to know what the decision is. And secondly, that there might not be merits in the appeal. So on either way, litigants foresee that the matter will be referred back to or that leave will be refused. In that case, they then know that they have to go to the Supreme Court of Appeal, and it is complete, as I understand it, it is practice, and not absurd at all, for litigants to lodge a dual, not a dual, but a contingent appeal to the Supreme Court of Appeal in the event that the Constitutional Court judgment is against them. So it's not at all unworkable or absurd that should be so, but that doesn't detract from the central pillar of the argument that really the Section 17(2) appeal is not correct.
Yeah, there's once again in the commentary by Erasmus, and as I say,
Yeah.
I haven't had time to look at anything more than that.
Yeah.
Stated as are ever generally not competent for a party to lodge simultaneous and separate appeals to the Constitutional Court in the same matter against orders of the High Court and the Supreme Court of Appeal dealing with the same issue. It is also not appropriate to apply to the Constitutional Court conditional upon the Supreme Court of Appeal refusing leave on the merits. Where the Supreme Court of Appeal refuses leave, a party has 15 days to apply, etc. And there's a footnote. Rules 13(2) and 25. Anyhow, I'll have a look at it.
Yeah, well, the central thesis that we present is that on the basis of Klute and the cases that Klute relies on, it's not proper or competent to appeal in any case in terms of 17(2)(f). It makes no point, and the courts say that. And just one final point on my own position, my lord.
Yes.
It's to typify my own behavior as unethical discounts the fact that we in the state work for the NPA. We act on instructions of our bosses. The decision as to who is to prosecute in cases or not is that taken by the relevant director of public prosecutions in consultation, usually, if as necessary, with the superiors in the National Prosecuting Authority, the National Director, or the head of the National Prosecuting Service. So I'm here on instructions of my bosses. whether they don't think that I should recuse myself. And finally, not recuse, but withdraw for ethical reasons. There are no such, and particularly in instances, we say, where an application has no merits, which we say this had none, and continues to have none, simply to say that we are then forced, and the NPA is forced ethically, somehow to withdraw their prosecutors when there are attacks against them like this, it cannot be correct, because it depends on the merits of the attack. The mere fact of an attack cannot be sufficient grounds to require that prosecutors willy-nilly then just withdraw from those cases and get other people to come and do their work for them. It doesn't work like that. And if it were so, our system of justice would be in a sorry state. It depends on the merits of the application, and the merits of the application will be determined in due course. While those merits are being determined, in accordance with the applicable law and orders of this court in this case, I'm the prosecutor, and I'm the prosecutor here with my boss's instructions, as it pleases the court.
Yes. Yes,
Sorry,
Mr. Woodley.
my lord, sorry, on that last point that you'd asked about whether we were going to make submissions, may I please retract, my lord, with respect?
Yes. What do you want to...
I've just been informed that there's pending correspondence between ourselves and the NPA with regards to this 41.6 issue.
Yeah.
And we request leave to then make a proper, write a letter to yourself before the end of this week, stating our position in a much more crisper
Yeah,
way.
look, I think I foreshadowed today what my concerns were.
Yes.
In regard to findings that I made on those 14 grounds, in the main judgment, and then also the position in the light of private prosecution and some of the points that were made in the correspondence that was exchanged regarding Mr. Downer. I want to deal with that issue, so what, do you want to make written submissions?
Did you want to deal with it today?
No.
No.
I don't think you're in a position to deal with it today.
No.
All the
And hence I'm
parties
saying
are.
we were going to answer your question in a much more.
Well, I think rather than correspondence, do it in the form of written submissions then. Are you content to do it in the form of written submissions?
In the form with what, affidavit or?
No, just written submissions.
No,
counsel.
written submissions are fine.
Yeah.
Yes, we will.
And to file them by
End of the week.
end of the week. Will that
Yes.
leave you enough time?
Yes, madam.
Well, that's an invitation that I'll extend to all the parties.
Thank you.
Yes.
That's
Thank
all.
you.
Thank you.
Yes, I need to reflect on the arguments that have been advanced and some of the authorities that have been referred to, or the authorities that have been referred to. Yes, I have some other commitments this week, so what I intend doing is I will adjourn this matter to Wednesday, the 19th this week, when I will give my order on that morning. Obviously, as before, the accused may be excused from appearing on that day. It'll simply be that I'm going to come into court and read out my order. And those that come from far, if you want to just instruct somebody to note the order, that's fine. Very well. The matter then is adjourned to the 19th of October 2022 on the terms that I've set out. Court will rise.
Right, can I just...
Sorry, Mr. Root.
On the dates issue, Maybe there was some miscommunication between Mr. Mpofu and I, because what I said is that I believe that the second term should be retained pending the development
All right.
as a trial date.
Are there a number of combinations and permutations
Yes.
that now arise?
Yes, that is
also
indeed
this
so.
issue that I want to consider my position.
Of course, I know.
So I'm looking at, without running ahead of myself, fixing as part of the order on Wednesday that any written submissions on that must be made by Friday, that the parties might wish to make. And then I want to decide what I'm going to do with or without reasons I'll see, depending on which way it goes. So that might also affect the holding date.
Of course.
So I might bring that forward, so to deal with that issue firstly. And in the meantime, the processes can run.
Understood.
Yes. Court will rise.